Hi, I'm Greg Dell with attorneys Dell and Schaefer, and today I'm joined by attorney Stephen Jessup, and we're going to talk about a question that we commonly get, which is how can New York Life deny long-term disability benefits without examining the claimant? And Jessup, this is a scenario that we see routinely because we've handled hundreds, if not thousands, of New York Life long-term disability denial claims, which was formerly Cigna Disability Insurance Company. And since the merger, which is going to be finalized in what looks like now 2021, it's basically the same thing. It's just the Cigna folks now acting under the umbrella of New York Life. But what allows New York Life to look at a claim, never examine the patient, and say, we disagree with your 1, 2, 3, 4, 5 doctors and don't think that you're entitled to benefits?
I mean, the short answer and the honest, the law, they don't have a legal obligation to send you to someone. Courts say, hey, you don't have to send out to an independent medical evaluation. You can rely on, doctors who do file reviews, internal doctors, even if those opinions are conflicting with, the person's treating physician. So legally, they have no obligation to do it, and it saves money to have it just review a file review as opposed to an actual in-person review. And I personally think, too, when you do send IMEs, like we've discussed, are dangerous. There's a lot of risks that come with them. But there's also, in my opinion, a better chance that that doctor may find that the individual is disabled as opposed to someone who's just looking at paperwork, not assessing someone's credibility, because a lot of the conditions that are disabling have subjective complaints. So it becomes really a credibility issue. You can see what person has on paper, medically speaking, but in the process of an examination, this is what happens with someone's doctors, they're also assessing if, do I believe this person's complaints, whether it be like something like migraines or pain from a back problem. So it's an easier, more efficient, cheaper way of doing it, and legally they're allowed to get away with it.
Okay, so you just threw me a lot of stuff,
Which
is going to be like a good summary of what we're going to talk about throughout this video. You said these IMEs can be dangerous. Can you clarify who's it dangerous for? What did you mean by that?
Historically speaking, it's usually more for the person who has to go. Like if we get a notice from New York Life that they want to send to an independent medical evaluation, one of the first things I do, it's a simple Google search really. And I try to see if this doctor is an actual practitioner. Do they have an office? Do they have their own practice? Are they in a hospital? Do they treat patients? A lot of times you'll see that these doctors only do IME exams. They're paid to do these exams. So in those situations, sending a client, when a client has to go to a doctor like that, the likelihood that that doctor is going to find in favor of New York Life is much greater as opposed to a practitioner. So anytime you go to an IME, it's dangerous for our clients, for the insured. What's going to happen? Not to mention when we extrapolate out over, if this ends up in court and legally when we're trying to argue that they acted arbitrary and capricious. Well, when an insurance company knows that they don't have to send you to an independent doctor, they can get away with that file review, and then they send you to an independent doctor who says, hey, I examined this person, I don't believe they have restrictions and limitations. They go, look, Judge, we even sent him to have someone examined. Look how reasonable we were in our evaluation. So the IME, sure, you get that notice and there's that concern, are they going to deny my case? But as lawyers, we're thinking 5, 6, 7 steps down the road if we find ourselves in court and what we have to prove. That's not to say that all IMEs come out negative. Just recently, I've had 2 clients who were sent to IMEs, and I requested the reports. They don't have a duty to give you the reports. Both times I got a response, we're not going to send you the reports, but we have approved benefits into the any occupation stage. So everything is very fact specific, but if you get a notice for an independent medical evaluation, there's reason to be legitimately concerned by that.
So I understand the danger, not physically like they're going to get hurt.
Yeah, for the case.
And definitely not dangerous in the sense for New York Life, but dangerous in the sense that it could more often than not lead to a denial. Okay, so shifting back now to New York Life making a decision without examining them, certainly if they do an IME, that would be an exam. When New York Life doesn't have the claimant examined, are they usually relying on their own doctors that are hired employees of New York Life, or are they using some kind of outside doctor that's just reviewing the medical records?
Generally speaking, what I find is on an initial denial, so if they're going to deny the claim for the first time, it's in-house people. Sometimes it's just a nurse a clinical nurse that looks at it, but it's more in-house people taking a look. And then if an appeal's filed, then they will go and they will hire outside people. It's almost like, hey, if we can keep it in-house, it saves us money in spending for reviews. And if the person puts up a fight, yeah, then we'll go out and we'll spend the money and have an outside doctor look at it. That's not always the case, but that's kind of a general trend that you'll see.
But isn't there a conflict? I mean, you have a doctor hired by New York Life, reviews hundreds of claims a week. What incentive does that in-house doctor have to approve the disability benefit claim?
From a conceptual standpoint, really none. When you get down to it, there is no incentive to do it. Obviously, claims are approved, so these doctors do find that there are certifiable restrictions and limitations. But in a lot of conditions that end up in disability, whether it be pain conditions, including things like migraines or mental health conditions, where a lot of your complaints are going to be subjective. Those are the cases that are going to get the most scrutiny, and those are the easiest. Well, we see you have this diagnosis. We just don't think it would, result in these problems being so severe, and that's where you'll see a lot of these internal denials. Even in the case when people, they'll say, well, they hired this guy who never examined me. He reviewed my paperwork, and they denied me. This guy was paid by them. It's a conflict of interest. You and I have both heard from defense attorneys, well, there's a conflict of interest with the person's treating physician. They want, they're treating the person, they are supporting the disability, so the defense attorneys will argue they have a bias to, support the client and not, necessarily say, oh, nothing's wrong with them. So there is that inherent conflict of interest, and if you get into court, that's always something that's going to be explored.
But here's another thing that bothers me, and I don't understand how it could ever be viewed in such a way that courts, when they get these things, they go, well, the insurance company doesn't need to defer to the treating doctor. They can rely on their own doctors, which is unfortunate because a lot of people go, well, that's okay that they're doing their thing. Isn't the court going to look to my doctors because they saw me? And the answer to that is no. Mm-hmm. But think about this scenario. You hurt your knee, you ask me for a doctor. You hurt your back or whatever, you ask me for a doctor, and I say, okay, I know Dr. So-and-so. And then you say, but I don't want to go see him. Can't I just send him my medical records? How often is that doctor going to say, oh, sure, just send me your medical records and I'll tell you whether or not I can help you or not and what's wrong with you?
There's no way that doctor would do that.
Right. Nobody could come up with any scenario, no matter who you know, and say, just send them the records and they'll call you right away and say what's going on. But yet, think about what's going on in a disability insurance claim. You're submitting your medical records. These in-house doctors hired by New York Life are looking at it, and they're saying, we don't think you're disabled, without ever speaking to the patient, without ever seeing them. So how can any judge then look at that and think, yeah, that doctor was in a position to reasonably evaluate the claim?
That's one of the million dollar questions with these things. How judges will defer and say that's okay. Into this idea of the treating physician kind of rule, giving deference to it. I mean, Social Security, in the past few years, even got away from that, and they just kind of give everyone an even playing field on it. That is a big question, a big concern, and a lot of times too, when we review these reports, these peer review reports where they're just looking at the file, the doctors never say, this person is disabled, not disabled. These are the restrictions and limitations I find. And generally speaking, if it's a pain condition, a physical condition, doesn't matter if you have a heart condition, if you have a back problem, any of this, they're going to kind of, give you this idea. We can look at it and say, oh, they're basically saying this person has sedentary physical ability as the Department of Labor would define it. And then the insurance companies will take that. And then my biggest argument is these doctors that are reviewing, generally, they don't really quite often know what the person did for a living, right. What their job was. They're just, almost giving opinions. This person can be a warm body in a chair, can sit for up to 6 hours and lift up to 10 pounds. And you may have been a CEO of a company. If life and work was that easy, everyone would be happy with their job. So they don't even put it in context. They're looking at it and say, I think this person can lift 10 pounds. There's no examination. So it's really like this really just stripped down, dumbed down, insulting to the person who's living this reality, the way that they do their reviews. And then it gets kicked back to a vocational person within New York Life to determine could the person do their own occupation or if it's some other gainful occupation.
The only positive to New York Life using all their own doctors, whether it's even in the application or even the appeal level, is that it makes it a lot easier for us to attack them in a lawsuit if we were to lose the appeal. So from that perspective, that's kind of the saving grace here, because all of the things we've been talking about how it's unfair, those are arguments that we make to the court, and most reasonable judges put a lot of weight into that particular argument, especially if you're someone who has multiple treating doctors versus just the doctor who's employed by the company. The judge is going to just naturally be like, yeah, there's clearly a bias on your doctors. These doctors, yeah, they're treating doctors, but they've seen the claimant. And so that works out favorable for the claimant a lot of times. And so, but on the in-house particular side for those doctors, the way I always think it should be done is they totally need their own doctors, because claims examiners don't know anything about medical. So they need to have someone to bounce it off of. And most times the doctor can say, yes, this person's disabled for these following reasons. I think they have this, or why don't you ask if they have this or that, and then I can better evaluate it. But if the in-house doctor at New York Life thinks that the person isn't disabled, there should be a go-to rule that they then refer it out because of that conflict. But yet, they don't operate like that. And the ultimate reason is because of the money. They don't want to spend the additional money. They'd rather just deny the claim and say either appeal, and maybe we'll do it later, like you said, on appeal, or sue us. And they can get away with that. And unfortunately, this is where the ERISA laws suck, is that there's no bad faith claim handling, there's no punitive damages, there's no reckless conduct for them. It's just if you sue them, if you win later, you get your benefits, you might get attorney's fees, you might get some interest. And so I really wanted people to understand why they do what they do, the pros and cons. You do have avenues to attack them, but more often than not, it's unfair. But that's the nature of the beast. And look, at the end of the day, they're the ones selling the policy. They wrote the language. They didn't really write the rules as to how it gets administered, but they have the ultimate say. And should you lose, you have the right to fight them. Yep. So thank you for taking the time to answer this specific question. I wanted to let people know that if you have a New York Life disability claim, whether it's short-term or long-term disability, feel free to reach out to Stephen, myself, any of our disability lawyers. We're always going to provide you with an immediate free phone consultation. No matter where you live in the country, we're available to assist you. Also wanted you to know that we have a ton of information available on our website about New York Life, where you can look up reviews on New York Life, past cases, things about your medical condition, your occupation. Search whatever it is that you're looking for, and I'm sure we have some helpful information about that. Also want to encourage you to subscribe to our YouTube channel by clicking the button below. We're publishing new videos on a weekly basis, and the point of these videos is to help educate claimants throughout the country about the long-term disability insurance process. The better educated you are, the better position you're going to be in to protect your long-term disability benefits. So should you need us in the future, we'll be here